welcome back to our channel Immigration Quick Tech. We hope you are doing great. So today in this video we will be discussing 5 most recent updates on H-1B fiscal year 2023 insights, USCIS extending the validity of green cards, temporary waiver of the 60-day rule, judge rejecting 2022 diversity visa winners, accusation of unreasonable delay, and Indian Embassy opening a 1 lakh visa appointment in November 2022. So to get all the information, pay attention and watch the video through to the end. Please hit the like, subscribe and do not forget to push the notification bell for upcoming episodes. USCIS extends green card validity extension to 24 months for green card renewals. As of September 26, lawful permanent residents who submit Form I-90 application to replace permanent resident card will automatically have their permanent resident cards, commonly known as green cards, valid for an additional 24 months. This extension may be granted to lawful permanent residents who properly file Form I-90 to renew an expiring or expired green card. The validity of a green card had previously been extended by 12 months through Form I-90 receipt notices. A green card's validity has been extended for persons with recently submitted Form I-90 by 24 months thanks to language changes made by USCIS to receipt notices for Form I-90s. USCIS started publishing updated receipt notices for people with pending Form I-90 on September 26. This receipt notes can be used as proof of ongoing status when a green card has expired. This extension is anticipated to assist applicants who encounter longer processing waits because they will have documentation of their legal status as permanent residents while they wait for their green cards to be renewed. You can request an appointment at a USCIS field office by calling the USCIS contact center. After you file Form I-90, we may issue you an alien documentation, identification and telecommunication stamp as proof of your legal permanent resident status while you wait for a replacement green card to arrive. USCIS announces extension of temporary waiver of 60-day rule for civil surgeon signatures on some forms until no later than 60 days prior to an individual applying for the underlying immigration benefit. Civil surgeons must sign Form I-693 report of medical examination and vaccination record according to USCIS, including Form I-485 application to register permanent residents or HS status. We have extended the waiver's original expiration date of September 30th, 2022 to March 31st, 2023 in order to lessen processing delays and associated challenges with finishing the immigration medical examination on time. Regardless of when the application was submitted to USCIS or when a civil surgeon signed the Form I-693, this waiver is applicable to all Forms I-693 connected to underlying immigration benefit applications that have not yet been decided. This exemption will benefit applicants whose applications have been hampered by the COVID-19 epidemic and associated administrative snags which occasionally caused immigration medical examination to slip the schedule. Many applicants, including Afghan nationals evacuated under Operation Ali's Welcome, who passed immigration medical exams but were unable to file for status changes within 60 days after a civil surgeon signing their Form I-693 will also benefit from this. Judge denies 2022 diversity visa winners unlawful delay claim. A federal judge determined that a group of individuals who were granted diversity visas for the year 2022 but sued the State of Department for unjustifiable delays in scheduling their interview would not be able to support their claim. The judge ruled that the 12 people who won a 2022 diversity visa through the yearly lottery will not be obliged to go through the interview process, even though the group had advanced further in the application procedure for their diversity visa. They claimed that other lottery winners had been allowed to jump ahead of them in the processing timeframe. The Biden administration is not compelled to schedule interviews for recipients of diversity visas. According to the judge's ruling, winners of lotteries are not guaranteed an interview. In fact, it is anticipated that almost all of the 2022 diversity visa will be granted, highlighting the Biden administration's good faith in issuing the diversity visas. The group that filed the lawsuit said they would lose their diversity visa as a result of the delays in setting up an interview, which let other candidates basically jump the line. The judge highlighted that diversity visa lottery winners are exempt from this requirement. The judge further declared that the State Department is not required by law to handle any specific visa application, that legal necessity has not been specified by a statute, a rule or court. Not at all of the 2020 and 2021 diversity visas were granted. As the COVID-19 travel ban only barred access to the US and did not restrict the government's power to grant visas, several lawsuits were brought asserting that the federal government was responsible for processing the applicants' applications. The court upheld these lawsuits. The judge determined there was no such improper delay in the 2022 diversity visa lawsuit. The State Department had 33,840 interviews scheduled for 2022 diversity visa recipients as of August 22, 2022. Embassies in India will open 1 lakh visa appointments in November 2022. The US embassies in India will offer 1 lakh appointments for H&L worker visa for drop-box cases in the upcoming weeks. First-time candidates are eligible for this prior to the global epidemic. Visa openings for new applicants haven't occurred in 2 years. However, given the tremendous demand, long wait times are to be expected. An Indian national must wait up to 800 days to apply for a guest visa to the US. The wait time for visas for student, exchange guest and other non-immigrant is close to 400 days. Naturally, the global epidemic had a significant impact on these lengthy delays. Additionally, student interviews will be made available by embassies and consulates. The availability of those interviews is anticipated to occur between mid-November and December of this year. The student interview slots will open in halves of the halfway point of October and in halves again at the halfway point of November. Appointments for FMNJ visas will be given preference. In the upcoming months, the embassy said they are actively striving to shorten the wait times for B1, B2 visa. These visas have a more than 800-day waiting period. Those with H-1B and H-4 work permits have also suffered significantly. All sorts of visa backlogs are being reduced by ongoing initiatives. By this time next year, according to the Minister Counselor of Consular Affairs at the US Embassy, staffing levels will be back to 100%. Additionally, he said that by 2023, embassies and consulates will be able to process more visas than they have in the past. He added that the organization understood their need to return and that those with H&L visa have not been permitted to travel back to India for visits since before the outbreak. H-1B fiscal year 2023 insights are important consideration as October 1st approaches. There are a number of significant factors to keep in mind as October 1st, the start date of H-1B fiscal year 2023 cap petition approaches. First, you might want to think about hastening the procedure if your petition is still outstanding and hasn't been adjudicated to a final decision. It is crucial that you are informed of any work permission and travel restriction that can have an impact on your situation while it is still pending. Next, if your request for a change of status was granted, it will take effect automatically on October 1st, so you must make the necessary preparations. Last but not least, if the H-1B's term and condition have changed since the application was first submitted, you must notify USCIS by October 1st before the new terms and conditions take effect. To do this, you must file an amendment which USCIS must receive before you can start working as a result of the revisions. In order to achieve complete compliance with all applicable immigration regulations, the article provided a detailed look at these concerns. Depending on your particular scenario, it also offers helpful insights. Considerations if H-1B approval is pending. First and foremost, you ought to think about switching to premium processing if your H-1B hasn't been accepted yet. In the first round this year, USCIS chose a record 1,27,600 cases out of the 85,000 H-1B fiscal year 2023 visas that were available, 65,000 under the standard ceiling and 20,000 under the master's cap. Since 42,600 more registrations were chosen by USCIS than there were visas available, it is logical to assume that as the H-1B season goes on, USCIS will run out of visas. We predict rising denial rates, more intricate RFEs, and increased USCIS scrutiny as time passes on. As a result, to secure approval while there are still H-1B visas number available, we strongly advise upgrading to premium processing if at all possible. Remember that the work authorization for the cap gap expires on September 30th as well. As a result, if your H-1B has not yet been authorized, you must stop working on October 1st if you have been working under the cap gap. Based on the active H-1B petition, you are permitted to stay in the country. Nevertheless, you are not permitted to work beyond September 30th. We predict that as cap gap authorization expires, many applicants will switch to premium processing so they can resume their employment, which will lead the amount of H-1B fiscal year 2023 visas available to fill up more quickly. This is just another justification for our current recommendation of premium processing improvements. We advise responding right away if you update and get an RFE, which is getting more likely. An H-1B approval is not guaranteed for you if an RFE has been issued in your case. In other words, USCIS's involvement in your case does not, in a sense, hold your place in line. If you take the entire 84 to 87 days to respond to the RFE, there could not be many H-1B fiscal year 2023 visas left by the time USCIS receives your response. Denial becomes more prevalent in the situation. With relation to specialty jobs in particular, USCIS has been issuing more intricate RFEs, giving them broad latitude to accept or reject the petition. If you receive an RFE, respond as soon as possible with the best supporting documents you have to guarantee acceptance. At the RFE stage, if you don't already have one, we advise engaging with a skilled immigration attorney. Consideration: if H-1B requested an automatic status change, it's crucial to stay in the country and avoid leaving until your H-1B petition for a change of status is authorized if you submitted one but it hasn't been approved yet. If you leave before receive a decision, your travel will abandon your request for a change of status. Thus, any approval won't include an I-94. It makes sense that travel could be more difficult to avoid with the impending holidays, considering upgrading your petition to premium if you absolutely must travel outside of the US so that you can receive the approval notice prior to leaving. Otherwise, before you may alter your status to H-1B, you must arrange to attend visa stamping. This entails either staying abroad until you receive the decision and traveling abroad for visa stamping before returning to the US, or returning to your current status and traveling abroad once again for H-1B stamping at a later time. If your H-1B fiscal year 2023 petition included a request for a change of status and the petition was approved with an I-94, the change of status will be effectively automatically on October 1st. The H-1B recipient may choose to remain in their existing status for the time being and switch to H-1B later in particular circumstances. Although it is not the simplest thing to do, there are some situations where it is doable through planned travel. Traveling outside the country on October 2nd and returning on a prior visa and approval notice, assuming both are still valid, will allow you to stay in the country under your previous status. Since you are not counted until you acquire an H-1B visa abroad or until your status changes automatically as a result of an acceptance with I-94, this will allow you to be counted against the H-1B fiscal year 2023 ceiling on October 1st. You won't have to enter another lottery if you let the automatic change of status take place on October 1st so that you can later file a cap exempt petition. You can stay in the country in that status up to the time that your H-1B term is ready to start after you leave on October 2nd and enter again with your previous visa and approval. You would need to file a cap exempt petition asking for a change of status from with the United States in order to finally convert your status back to H-1B, or you would need to leave the country to attend H-1B visa stamping before returning with your current H-1B approval. Please be aware that while this will work for someone who is presently in the country on L1 or H4, it is not smart choice for those who possess F1 status and want to continue working under OPT. The SEBIS record for the F1 student is closed when an H-1B with an automatic change of status is approved. The only option to get the SEBIS back in operation would be to file an H-1B withdrawal before October 1st and then have the school ask for a data repair. You would not be counted against the cap because this would necessitate withdrawing the H-1B prior to the automatic change of status taking effect. Thus, you would have to enter another lottery in order to change your status back to H-1B in the future. Finally, it is crucial that you submit the H-4 petition by October 1st if you requested an automatic change of status with your H-1B petition but did not do so for your dependent who are in the country in another status. Otherwise, your dependents will be out of status when your status automatically switches to H-1B. Consideration: if H-1B is approved but terms and conditions change, it is crucial that you file an update with USCIS before October 1st, the day your H-1B status starts, if there have been any significant changes to the terms and conditions of your employment, work location changes, end client changes, title changes, etc. You are prohibited from working until the amendment is filed. If not, until the update is submitted to USCIS, you are not permitted to work in accordance with the revised condition. If the terms and conditions of the employment have changed materially since you submitted your H-1B fiscal year 2023 petition, For consular processing, you will also need to file an amendment before you can go to visa stamping. If the information in the petition has changed, you cannot attend the visa stamping and provide the old information. It will be deemed as substantial misrepresentation and the visa will be rejected if you show up for stamping with the outdated project documentation. This can make it even more difficult for you to get a visa in the future. As a result, if there are any modification, submit an amendment petition asking for consular processing and show up for stamping using that authorization. So this is it all in this video. What are your thoughts on this? Please let us know in the comment section below. Hopefully the video is useful to you. Thanks for watching the entire episode. See you in the next episode. Till then, take care. Bye-bye.